Mr. Waite.
If I may, I'm going to shuffle my order slightly and take the procedural point last, because I think it's going to break the flow if I go to it now.
Take it in your own way.
So I just, before moving to the jurisdiction paragraphs, I want to take you briefly, please, to some decisions where I say court or tribunal has adopted essentially the stance of the Secretary of State in this case as to the interpretation of Abbas. That's a tribunal in each instance. The first is at tab 13. And that is a case of SD Sri Lanka. SD Sri Lanka is a sort of unusual case factually. It concerned a Sri Lankan, you can see this from paragraph 2, page 340, but it concerned a Sri Lankan national who married a British national. However, the appellant, who was the Sri Lankan national, resided in Sri Lanka, and she resided in that country with her 2 children, both of whom were British citizens. And it was the appellant, the Sri Lankan national's application for entry clearance to join her spouse in the UK, which was the subject matter of the case. Most of it is not relevant to any issue that you have to decide. It relies substantially on family life, but there was a discrete private life claim that was also brought in that case. And that's in paragraph 13. That is paraphrasing.
Which paragraph?
Paragraph 13 on page 343. And what counsel did in this case is seek to distinguish the facts of that appeal from the circumstances before the Court of Appeal in Abbas, on the basis set out therein. We then turn to paragraphs 72 and 73 of the decision, which is on pages 364 and 365. Moving to the bottom of page 364, he acknowledged that at first sight, this is Mr. Lewis, this limb of his argument was contrary to key court of authority, but submitted that the appellant's case can be distinguished from Abbas in several respects. And then the paragraph which I rely upon is the next one. It's particularly those words: we are unable to accept that in this decision the Court of Appeal envisaged any exceptions to its broadly expressed statement at the level of principle that the right to respect the private life was not engaged in entry clearance. The other case where I say that a tribunal has, in essence, come to the same conclusion is a SIAC case, and that is the case of R3 at tab 17. I'm sorry, that's the wrong. No, I'm not. It's sorry, U3, tab 15. So, tribunal was presided over by Mr. Justice Chamberlain. This was an entry clearance case, albeit one that took place in rather unusual circumstances. You'll see that in essence, in paragraphs 1 to 4, that U3, the appellant, was a British national who travelled overseas and was deprived of her British citizenship due to perceived extremist links, and then unusually her children were repatriated to the UK, in that's paragraph 4. That is the factual background. And what the tribunal did, albeit in remarks which are obiter, and I'll come to the note, is consider the question of the engagement of Article 8 in respect of cases where the appellant is outside the United Kingdom. And if we come to the key part of the decision, it's a paragraph 47 on page 492. So they say that the resolution does not affect the outcome of the case. We conclude that the correct position is as follows. Subparagraph A reflects the Article 1 principle. Paragraph B, since U3 is not within the territory of the UK and did not fall within any of the categories of non-territorial jurisdiction, the UK is not obliged under international law to secure her Article 8 rights, but is obliged to secure those of her children.
That covers family life as well, doesn't it?
Exactly. And paragraph C, and they talk about the exception to that principle, which I say is consistent with the conclusion of the court in Khan, may be able to rely on the positive obligation imposed by Article 8 despite being outside the jurisdiction if she has a family member inside the jurisdiction. And then at the end of that paragraph, this seems to us to show that in cases of this kind, the Article 8 rights engaged are in principle those of the family members in the jurisdiction. And then in subparagraph D, deal with the point about family life. It's sometimes being artificial to separate family life, and that's a reference to a paragraph in the
Isn't that all based on Khan rather than Abbas? It's certainly not the principle in Abbas that you're relying on. It's another bit of Abbas, which relates to realignment of the family. It's the bit in Abbas in paragraph 19, isn't it, rather than the paragraph 18, which is the linchpin of your argument.
Well, since you I say that subparagraph B is what the Court of Appeal decided in Abbas. So whether they are drawing that conclusion from Abbas or
Well,
from
it goes
Khan.
further than Abbas.
Yes, it does.
And contrary to the exclusion cases that we were showing this morning.
Well, it goes further than Abbas. Well, it arguably goes further than Abbas. I shouldn't concede it does go further than Abbas. It arguably does, in the sense that it states that the relevant Article 8 rights which are engaged in a family life case are those present in the UK. And there's no express finding to that effect. Although it might be said that Abbas, by implication, finds that by referring to the jurisdictional peg, which I will come to in a moment.
Thank you.
So the simple point is I say that the Secretary of State's submission, central submission in this case, is consistent with the conclusions reached in both of those cases, which I referred you to. If I may now turn to the status of paragraphs 23 to 25 of Abbas. So that's tab 10, pages 275 to 276. It is obviously right to note that in paragraph 22, before I come to the interpretation of those paragraphs, I should clarify their relevance in this appeal. If you are with me in relation to my primary submission, which is the ratio of paragraphs 18 to 21, then I say you don't need to decide the status of paragraphs 23 to 25. If you are not with me in relation to that submission, then I respectfully submit that you should decide the status of those paragraphs, because if they are either binding or they are right, then it follows that the first tier judge had no jurisdiction to consider the Article 8 appeal. I accept that paragraph 22 suggests at first sight, at least, that the paragraphs which follow are not necessary for the decision and therefore not binding. But what I say is that those conclusions have been implicitly endorsed by this court in the case of R3, which we looked at earlier in relation to its description of Abbas. R3 was a case about the deprivation of citizenship. The Article 8 claim was fundamentally different from in this case, and if you look at page 545, that's tab 17, page 545, just briefly. Middle of that page, second paragraph, he then applied to amend his grounds of appeal to argue that the deprivation decision was contrary to Article 8 of the ECHR because there was a risk of arbitrariness and the decision had not been foreseeable enough to be in accordance with the law.
Procedural Article 8 rather than substantive
Yes.
Article 8, yeah.
I think the next logical point is to look at the issues as summarised in paragraph 102, which is on page 568. Was within the jurisdiction of the United Kingdom for the purposes of Article 4 when the ECHR, when the decision went, and if so, did the decision breach Article 8? Those are the two relevant issues. The next step is to assess how Abbas was relevant to the assessment of those issues. And the appellant's counsel's position is recorded in paragraph 93, which is on page 566, the bottom of that page. So his case was that the presence of the appellant's family members in the UK was the jurisdictional peg, which then entitled the court.
That was his primary case.
Yeah.
He had a secondary case.
That's right, yes. He had a secondary case.
Ties to the United Kingdom for former citizenship. So here they would argue, having lived here for all his formative years and having had indefinite leave to remain.
Yes. So the next step in my submission is to look at the Secretary of State's response to that, which I say is essentially adopted by the court. Paragraph 96. This is Mr. Dunlop's submission. And it's really Roman numerals 2 and 3 upon which I place principal emphasis. Article 8 only applies in an appeal when the appellant is outside the United Kingdom if he appeals against a refusal of entry clearance for the purposes of family reunion. The presence of members of an appellant's family in the United Kingdom is only a jurisdictional peg in such a case. So in that type of case, if the appellant has applied for family reunion, And what I say then happens is in paragraphs 103 to 106 is the court in substance agreeing with all of those submissions. And I place particular emphasis on paragraph 106. Particularly these words. It would only become relevant if A were to apply for entry clearance to visit or to be reunited with them. If it did not, when the decision was made, I say what they're then saying in what follows, is that if that condition is not met, then the relevant jurisdictional peg is not there. What, in my submission, the court are saying in that paragraph is the presence of family members in the UK, in this case children, is a jurisdictional peg in family reunion cases, but not otherwise. So they are, in my submission, implicitly limiting the jurisdiction of this court to consider Article 8 cases based on entry clearance, at least, to that scenario. I don't ask you to turn it up again, but I also say that the conclusions of Mr. Justice Chamberlain and his colleagues in the U3 case at tab 15, paragraph 47,492 are consistent with that conclusion and have persuasive value. So in my submission, it should be regarded as a principle which is both right and has been adopted by this court. And it is a further reason why the appeal should fail. If I could next respond to the exclusion line of cases, I'm putting it in those terms upon which Mr. Westgate relies. In my submission, they are fundamentally different from entry clearance cases. And they're much closer in substance to a case of expulsion. Because what you are doing is preventing somebody who already has an entitlement to be in the UK from returning. He already has that entitlement. So it doesn't engage the issue of principle, control over borders, and so forth, which was relied upon in Abbas.
Well, he doesn't have an entitlement to be in the UK if he's been excluded.
well, I suppose it's similar to expulsion because you're removing a pre-existing entitlement, is the way I would put it.
The thing that's puzzling me, and I'd be grateful for some assistance from you with, is why it is that on your analysis, someone who stays here for X number of years, establishes a private life here, and then goes off to fight for ISIS in Syria, and is excluded whilst abroad, can seek to rely on Article 8 to get back because he's been wrongfully excluded, he says, whereas somebody who's lived an utterly blameless life and loses his passport can't.
I think it's in essence because the former case doesn't engage the issue of a state's entitlement to control borders in the same way and with the same consequences. It's much closer, I say, to expulsion. It doesn't cut across that right.
I'm struggling to see why not. It's the same right, and surely it could be said that as a matter of policy, the state's right to control entry to its borders by people who are liable to want to blow other citizens of the country up in terrorist bombs is even more strongly engaged in that sort of case than somebody who's lost their passport.
Yes, I mean, I think I should also preface it. I don't think there is any clear authority. It is to the effect that it is engaged in an exclusion case. I have to say that.
But Strasbourg seems to be going that way.
Well, the authorities seem to say, for the sake of argument, we'll assume it's engaged. But I don't think I would concede that there's been any decision to that effect that in an exclusion case it is engaged. So that would be my first point. But in relation to the wider point, I think as a matter of policy, you have to draw the line somewhere.
Yeah. It just seems a rather odd place to draw the line. I mean, I take your point about floodgates, that the state should be entitled to say who can come into the country and who can't. That I completely understand, and you can't just apply private life willy-nilly so that anybody can say, I want to come in and visit Auntie Flo, and therefore my private life is engaged. So I completely get that point. But at the moment I'm a bit struggling with why it is that as a matter of principle there is a different engagement of that right, that fundamental right to control your borders, in circumstances where somebody's been here and then does something bad or behaves in a bad way and is excluded or expelled when they seem to have the right to come back, or at least argue that they got the right to come back on the basis of that private life, and somebody who's totally blameless goes abroad for a holiday, loses their passport, hypothetically, I'm not saying that's this case, and then can't. It may be that the answer is, well, as a matter of policy, they've got a different route in without having to rely on their private life.
Well, I mean, I think... I mean, it's a matter of fact there's a different route, but in my submission, that there is a distinction to be drawn in terms of immigration control between people who are already there, already in the country, and the world at large who are yet to enter. There is a valid distinction to be drawn between those two cohorts in relation to immigration control.
Yes, I can see that too if the Strasbourg jurisprudence hadn't extended to people who'd been excluded and were overseas.
Yes. I mean, I'm not sure they have. I don't think I'd accept they have, but
on the face of it, it looks as if they have.
Well, my reading of the law is that there is no decision to that effect.
Right.
And the construction I would invite the court to adopt is that if you disagree with me on that, it should be regarded as a subset of the expulsion cases.
Right. just so that I get this clear, you say that in principle there is a distinction to be drawn between people who are already here and people who are abroad.
Yes, I do. Well, one is a group of people confined in number. I know it's a controversial area as to how many people are allowed in, but it's still confined in number under the control of the contracting state. In relation to the other cases relied upon, there is the case of Sargsyan, if I'm pronouncing it right, which is at tab 8. I have to agree with my learned friend. Factual background, as set out at the beginning of the decision, is incredibly complex and difficult to follow. In my submission, paragraph 29 onwards of the decision provides the most comprehensible description of the facts. The key point, which arises from those paragraphs, and indeed in particular paragraph 32, key point is that the applicant was an ethnic Armenian who was forcibly displaced from his home in Azerbaijan. And then moving through the chronology to the essential points, paragraph 40, he fled to Armenia where he obtained citizenship in that country. There were numerous issues in this case which were of no relevance to the question in this appeal. Much of it was devoted to whether Azerbaijan had jurisdiction over the area from which the applicant fled. The court concluded it did. The Article 8 assessment is at paragraph
252.
It is indeed.
It's 243, doesn't it?
It is indeed. I'll go on. Yes. I've placed, and this is in the skeleton argument, paragraph 25, emphasis on paragraph 257. The gist, the court therefore accepts that the applicant had a home in Gulistan which he left involuntarily. The gist of his complaint is precisely that he's been unable to return ever since. in my submission, this case is of no assistance to the court. It's a unique case which turns on its facts and is authority, if anything, for the proposition that somebody who is forcibly displaced from their home, a place which they found continued to be his home, on my understanding of the determination, has or may have an entitlement to return.
So you draw the distinction between forcible displacement and leaving on health grounds?
Absolutely, I would say that this is certainly the case.
And that principle is what?
Well, forcible displacement is akin to an act of expulsion, in my submission.
No, but how does that relate to your principle as to the borders, maintaining the borders? In both cases, the individuals are blameless.
Well, providing a right of re-entry to somebody who is forcibly displaced has no implications for border control in the UK.
Because they shouldn't have left the country at all.
Yeah.
And so what you're actually doing is restoring the status quo.
I've described this as a subset of, or it can be seen as a subset of an expulsion type case, because the person has been effectively forcibly removed from their home.
But then could you not say that denying them a right of re-entry when they had one, by reason of wrongly saying they didn't have the right document, was analogous?
I would say that is not analogous at all. There's nothing here which could be described as analogous to an act of forcible displacement. The appellant left voluntarily.
So there's a difference in kind between any form of voluntary leaving the jurisdiction, even if it's only intended to be for a very short hot visit, and not getting back in, and a situation where the state throws you out basically when they shouldn't have done.
Yes.
Yeah. Because you say in the latter case, the wrong which is being addressed, the interference with the private life, it consists of the forcible displacement in the first place, and consequently their private life rights have been engaged by that factor at the time of leaving, and it can't be said that jurisdictionally there isn't a private life claim, therefore, because they are outside the jurisdiction. Is that how you square it?
I think on the facts, I'm trying to find the
Just trying to see how you've
I think
squared this with the jurisdiction
point. I'm still trying to find the passage, but the essential finding is in Sargsyan was that the place from which he was displaced was and remains his home.
Yes.
Was and remains his home.
Well, you can get that
With-
from
with-
the first part of 257. I think it's somewhere else as well, but you do get
Yes.
the first.
Um,
So it isn't always was his home.
yes. So if you are looking for the jurisdictional peg, the case can be viewed in those terms, as forcible as falling within the jurisdiction.
But on a private life analysis, surely, because see what I'm trying to do at the moment is test your proposition that you can't have jurisdiction under Article 8 on private life grounds if the person concerned is outside the jurisdiction. Now here we've got somebody who's outside the jurisdiction, not through his fault because he's been removed forcibly. He's developed a very strong private life here because it's his home and is continued to be viewed as his home. And this case seems to suggest that he could apply for some form of entry clearance to get back, relying on his private life in Article 8.
Well, I mean, it's not an analogous situation because he left the UK voluntarily. He remained outside of the UK for over 2 years.
Yeah, but forget the facts of this case at the moment. I'm just testing the principle. The principle you're putting to us is that you can never rely on private life for Article 8 purposes jurisdictionally if you're outside the UK at the time of the decision complained of. That's the proposition you've been putting to us, as I understand it. You can't do it. So you don't even get your claim off the ground because there's no jurisdiction to entertain an Article 8 claim. But this case seems to suggest to me precisely the opposite, because it's a case where it is an Article 8 private life claim, albeit that it rises in, as you say, very different circumstances where somebody's been forcibly removed. They're still not here, they're still over there.
But as I understand it, that's where your immigration policy comes in.
Yeah.
Because you say...
Attention please. Attention please. This is the Incident Control Officer. Attention please. Attention please. This is the Incident Control Officer. A report has been received of a suspected fire in the main building. This is being investigated by the security fire team. All fire evacuation and first aid officers to alert status. Please stand by for a further announcement and obey the instructions of your local evacuation officer.
But we're...
This will go on for some time, I'm afraid.
Attention please. Attention please. This is the Incident Control Officer. A report has been received of a suspected fire in the main building. This is being investigated by the security fire team. All fire evacuation and first aid officers to alert status. Please stand by for a further announcement and obey the instructions of your local evacuation officer.
We're not in the main building, we're in the East Block. So, notwithstanding that we had a genuine fire the other week due to an electric scooter, I think we're fine to carry on. So, Mr. Waite, I mean, sorry, that does interrupt Council's train of thought when these happen.
No, I think what Lady was saying, I think that is the distinction.
I think you were telling us that even if one accepted the lady's premise completely, which I know you don't, but even if one did, you say in any event it all comes down to the rights to control borders.
Yes.
Yes.
And that's very different when you're talking about the world at large, outside the country, and a more limited, albeit undefined, pool who are within the UK.
Yes.
So we understand now. Where do we go from there?
So I'm just going to move to the case of MN Belgium, which is at tab 12. My learned friend relied, I think, particularly on paragraph 109. The difficulty with that paragraph is that what hasn't happened is reliance upon any of the cases which the court cite at the end of that paragraph. They are, I am going to respectfully ask for permission to put in written submissions simply describing those cases because they're not before you.
Why?
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 Because they are fundamentally different. I can describe them. But
We've had lots of cases cited to us so that people can make the point that they're fundamentally different to this case. I know this is immigration and asylum, but sometimes these cases turn on the facts, not the endless citation of irrelevant authority.
well,
In my view.
I mean, this is hardly at the heart of either of your submissions, this case. And we've already had supplementary authorities.
Attention please. Attention please. This is the Incident Control Officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing. Attention please. Attention please. This is the Incident Control Officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing.
There we are, Mr. Waite, back to normal duties.
the simple point I was simply going to make is that two of those cases, Orlandi and Shembri, are family life cases. Sorry,
There we are.
Nessa and Shembri are family life cases.
Well, there we are. You've told us that. We don't need written submissions.
Yeah. And Orlandi is nothing to do with entry clearance at all. It is a private life case. It's about the rights of an Italian couple to register.
We don't want any more written submissions, thank you.
Thank you. But I would simply repeat the submission I made earlier. There is no precedent for...
Well, we have that firmly in mind.
I think that those are the submissions I make in relation to the substantive issues.
Now, are you pursuing your procedural objection?
I will, I'm afraid, very briefly. I won't be long. In my submission, the principle in Abbas is entrenched and established. I submit that given that fact, there was no obligation upon the immigration judge to inform the parties in a case in which they were professionally represented, one by qualified lawyers, another by a Home Office presenting officer, that he was intending to rely and apply the case. I say the case is analogous to the many other decisions, and I've referred to them in my skeleton argument, which are routinely relied upon by the tribunal. And I say with respect that what ought to have happened in this case is what did happen in the case of SD Sri Lanka, which I've already taken you to, and ask you to turn it up again, which was the appellant's counsel in that case, seeking to distinguish Abbas. I don't know whether it was expressly drawn to his attention by the tribunal, but in any event, that is, in my submission, is how the law should operate in this field. If there's an established principle, the parties could expect it to be applied in the absence of argument to the contrary.
It might be said against you that if it was an established principle, then the Secretary of State should have relied on it expressly.
I think, my lord, that's a very fair point. But
we have an
doesn't.
adversarial system.
You see, on the basis of your very careful and detailed submissions today, surely the representative of the Secretary of State should have gone into the FTT and said, it's an Abbott case. An end of. There's no jurisdiction in any event because of paragraphs 23 and 24, 23 to 25, and in any event, it's bang on the principle. Dead easy, FTT judge.
I think that I accept that that is a fair point. I do not suggest, however, that it carries sufficient weight.
One of the reasons I asked you whether, in fairness, you were going to pursue your procedural point.
I will. Thank you. I'm not going to say more about it. Apart from to rely on my skeleton argument, I also say this is the CART judicial review.
Yes.
We're very conscious of that.
Thank you very much, unless there's further submission.
Anything else? Thank you very much indeed. Anything in reply, Mr. Westgate?
The 3 points. One is to do with the immigration control policy consideration. The second is to do with jurisdiction, and the third is to just pick up a couple of points on the additional cases that were referred to, SD and U3. So far as exclusion and or rather immigration control is concerned, one can readily understand the point that's being made about the entitlement of the state to control immigration and the importance of controlling it. But at the end of the day, it's difficult to see how those objectives and the particular aspects of them can stand behind or provide a justification for what's said to be the wider ratio Abbas, because the concern ultimately came down to, well, that there are just too many cases, or it may just be, and it's in effect a floodgates argument. But the solution to that can't be to say, as a blanket rule, that certain kinds of case are simply excluded from the ambit of Article 8 altogether. Article 8 either applies or it doesn't. If it's engaged, then you can't simply short-circuit the process by saying, well, we're choosing not to allow claims of that kind, because the next step is proportionality, whether that's dealt with under a positive duty analysis or whether it's dealt with under an interference analysis. And there were two particular aspects to the argument that were put forward. One was, and what we'd say is that all of the concerns can be accommodated within that traditional framework, rather than the framework that is sought to be derived from ABBAS, which we say is unprincipled and unsupported by any authority. The two aspects that were particularly pressed on the court were firstly, that there may be all sorts of cases where people have some involvement in the UK and then leave. They're talking about people coming for work or study or something like that. And the concern is that that group could then make applications based on their private life. The reality is that applications like that are vanishingly unlikely to succeed on a proportionality basis. If someone is seeking to enter for a short period, then it's very unlikely that that will have a sufficient value, as it were, to outweigh the concerns of immigration control if they're not otherwise within the rules. It's for that reason that ABBAS and ONURA were one analysis of them is say, well, they're visit cases, and when someone visits, that has so little impact that one simply can't say that there's a justification in those circumstances for saying that it's disproportionate to not allow them to enter, given the limited impact it will have on them. So if what's being sought is that quality of entry, then it's very unlikely that Article 8 will be engaged, probably, or if it is engaged, it will be a proportionate solution. If they're asking to enter for some more extended purpose, then that fails for a different reason. Well, why should someone be entitled to enter for a more extended purpose but to build on something that was less than that in the past? And that's quite apart from the fact that very often in those cases it's going to be possible to say, well, there's no continuing private life because you go and you study somewhere and then you leave, and you leave behind that chapter of your private life. So there's no realistic, one has to have a certain dose of realism here about how those kind of applications will be dealt with. And this is a very, very different case from that. I'm not going to go back over the facts of it. The other aspect that was relied upon was, well, there's a difference between expulsion and other cases. But with respect, that proves elusive when you try to unpick it. And again, what it comes down to is an argument that says, well, there are fewer people here who we are expelling than there are out there who might want to come into the UK. But again, that can't be analysed in terms of a blanket rule, whether or not Article 8 is engaged. If Article 8 is engaged, then the consequences follow. If it's not, then they don't. But equally, on the facts of this case, it's an argument that fails on the premise, because it's impossible to say that the class of person that the appellant belongs to is one of this large amorphous group that outweighs those who are being excluded. It's a point that was made in argument, I won't repeat it. Just on one of the cases that was referred to, Sargissan, which was also sought to be analysed in terms of being an expulsion case rather than anything else. That's when one looks at paragraph 257, I won't ask you to turn it up. It's what the court stresses isn't the forcible displacement or the expulsion, but the inability to return. Is the heart of the interference that's being complained about, and that is has a direct read across to this case. So that's the policy point. So far as jurisdiction is concerned, the first point I'd make is, and I don't want to get into procedural points about whether this is a new point or not a new point, but the fact is it is a new point, and the bite that has for the purpose of this case is that what is clear when one goes to MN, and I don't, in particular the passage, paragraph 96 there, where they start the discussion, this is a factually sensitive area. Whether one of the exceptions applies depends very much on a close examination of the facts, and that, of course, didn't happen here. And we would suggest that the right way to deal with this, if there is a live jurisdictional issue, is not to decide it, but to leave it to the Upper Tribunal to decide if that's part of the merits of the claim. If of course you feel that the right solution would be to allow the appeal, because it wouldn't be right for this court to assume facts and on that basis say that there is no jurisdiction. Because what is clear is that one simply can't say that because someone's outside the jurisdiction physically, then there is no jurisdiction. And just to come to how that fits into the facts of the cases that you've been
That
referred
does seem to be the submission that Mr. Waite is making. He does seem to put it that high.
No, he doesn't. But what he...
Except for family life cases, is the way he put it. As if somebody's outside the jurisdiction, there's no jurisdiction unless you happen to have a family member here, in which case you can grab onto their Article 8 rights in order to piggyback a family life claim. If it's a private life claim, you're outside the jurisdiction, that's a knockout blow.
Well, but what paragraph 109 of MN demonstrates is there is certainly a class of family cases, private life cases. Which confound jurisdiction, the passage I showed you. And what may or may not be said about the boundaries for that will depend on the factual circumstances of those individual private life cases. And therefore it's not open to Mr. Waite to say, well, there can never be a private life case that founds jurisdiction. And when one comes to Abbas, it's not any authority to the contrary. What paragraph 24 says, it's page 275, is that the consistent approach of the Strasbourg court has been to say that it's primarily territorial jurisdiction, and then to say that there are exceptional circumstances that may constitute an exercise of jurisdiction. Then it says none of the exceptions thereafter identified by the Strasbourg court, that's in Elscani, has any bearing on the fact of this case, which may be right. And then goes on to say that in Article 8 cases, the position is it's the Beocupet's point, the jurisdictional peg. But all that those paragraphs say is that in this case, none of the jurisdictional exceptions apply. That court doesn't. What the earlier passages in that judgment make clear is that the Uller principle applies, and so that the court will be applying whatever Strasbourg applies in this context. And in Abbas, there's no discussion of NA, and no discussion of the possibility of this being a private life case where jurisdiction is grounded. And for the obvious reason, we suggest that in Abbas there was no such private life, and so the point couldn't be run anyway. So
couldn't have been any discussion of MN, could there?
No, you're quite right, because MN hadn't happened.
I was going to say
no. But I suppose the point could be is then available to us to say, well, although one can't use subsequent Strasbourg authority to say that an earlier decision should be overruled or is per incuriam, what the effect of the ratio in Abbas is, if this were part of the ratio, which we don't accept, is that we will follow what Strasbourg does. And then if Strasbourg develops, then it's perfectly within this ratio to say, well, we are now following that. But it's something which simply didn't arise in Abbas, because the private life point simply wasn't made out. So far as R3 is concerned, it's, like all these cases, very much something that turns on its own facts. And it's important perhaps to start by observing what happened when the court in that case, Justice Elizabeth Lang, addressed the substance of the private life claim. And that's at paragraph 108, having made the point that the, well, perhaps if I started with the earlier, the paragraph before that, which is to do with the removal of citizenship, which it's really the end of that paragraph, where it says the effects on A of the decision were limited, as he'd voluntarily left both the United Kingdom and his family here. He didn't wish then to return to the United Kingdom, wasn't stateless, and if, contrary to Sykes' clear finding, Article 8 did apply when the decision was made, Secretary of State didn't breach Article 8, then paragraph 108, with the exception of A's former citizenship of the UK, the links with the UK on which he relies on are analysis not links at all or are tenuous. He's got set against his links in Turkey, citizenship of Pakistan, and so it's someone who in effect has abandoned the UK, is the thrust of it. And so in those circumstances, it's perhaps unsurprising that the emphasis isn't given to the possibility of making a further claim under private life. And so it's, although you were referred to paragraph 103, which I think I may have got the wrong paragraph.
106?
It's
106.
106.
it's yes. So the point in 106 was that an application under paragraph an application for family life might engage Article 8 if such an application was made. Mr. Waite added parenthetically to that, and no other kind of application, but that doesn't follow, and it's easy to see why it wouldn't have worked on the facts of this case, but it doesn't mean that in an appropriate case you can't have a jurisdictional peg provided by private life, and the point about the absence of any personal factual connection with the United Kingdom that I've been developing in relation to paragraph 108 also appears in relation to 103, where the judge there refers to no decision of the ECHR which concerns a person deprived of his British nationality who was outside the UK, having left voluntarily, was a dual national, and was living in a family unit outside the UK when the deportation decision was made. So it really is a case of someone who can't, in effect, make a claim to private life, having abandoned the UK in that sense. And it's a very different case from this one, where someone who wants to return, but is being prevented from doing so for factors outside his control. Just dealing very briefly with SD and U3. SD was a case where the private life in question was that of the applicant, SD, who was the mother of 2 British citizen children, but it's difficult then to see why the citizenship of her children should have a bearing on her private life, because her children don't have their private life interfered with. They can return to the UK whenever they want, without hindrance. Whereas her position was that she had never lived in the UK. She had married in Sri Lanka, and the facts are, paragraph 76, I think, explains that they met and married in Sri Lanka before the husband went back to the UK, but she didn't. So all of her private life was in Sri Lanka. And so in those circumstances, it's indistinguishable from Abbas, and it takes the case no further. U3, Mr. Waite accepts are obiter statements, and in fact the observations that are made seem to be observations that are purely about family life, But it also seems to be the case when one looks to paragraph 45 of that decision, and I won't ask you to turn it up, that it was a case where there wasn't any argument on the point, and these seem to have been agreed propositions. So it doesn't really help. And of course, neither of those cases is binding on this court. Would you be able to move that? Unless there's anything else.
Yes. Thank you very much, Mr. Westgate. Well, may I thank you all very much indeed, and also those behind. You won't be surprised to hear that we're going to reserve our judgments in this matter. I can't tell you precisely when they'll be sent out in draft, but as soon as reasonably practical. They'll be sent out in the normal way for typographical and minor factual infelicities, but not for re-argument, please. And they will subsequently be handed down electronically in the newish now way. If there's any other matters, we'd go with them on paper, and I'd hope you'd be able to agree in order at the end of the day. I don't think it's of any great import in this particular case, but I would remind you of the terms of the embargo that appear on the front page of the draft. So unless there's anything further that we need to deal with today, thank you very much indeed.